to thank you all for coming today and joining and partaking in our coffee talk. We understand that so much is happening around the world, and I want to apologize. I'm not used to doing conferences in Zoom, but it's a new world. So much is happening in the world with immigration that we decided to do these coffee talks every 8 to 12 weeks on immigration and employment, immigration and estate planning, immigration and travel. And we thought these would be comprehensive webinars that bring practical advice to people who are interested in these topics and highlight these issues. Today, end of July, we'll do one on Mexico and Canada and the border issues with Mexican and Canadian conflict. So we will keep going on these. Today, we're very, very lucky because we have the incredible subject experts, two partners at our firm, Peter Siegel and Marcela Bermudez. These partners, I'm happy to call my colleagues, and they both have over 15 years of experience in their field. They are both well-known. Peter is well-known in employment law. He is nationally recognized in this area. Marcela is nationally recognized in immigration. They both have extensive articles, and they are extensive speakers, and they are here today to help us. Now, when we originally came up with this seminar was supposed to just be about different issues in employment and immigration and how they merge. But since then, we've added what we call the elephant in the room. And this elephant is the latest proclamation from our White House, which affects immigration. So we thought today we would just be a little fluid because we have to be, and that we would invite Ms. Bermudez and Peter Siegel to opine on some of this. So without any further delay, Marcela's going to talk about that. And then afterwards, Mr. Siegel is going to discuss COVID and the beginning in employment law, when we first remember that we had to leave our offices, what that impact was, layoffs, furloughs. And then, of course, came the CARES Act and PPP. And then, of course, some areas of the United States are thinking about coming back to work and what that means for the employer and the employee. Finally, we're going to end with any questions that people might have as we review the chat box. So let's start with the elephant in the room, President Trump's proclamation that was just issued June 22nd. Marcela, can you help us out there?
Sure, thank you. I was going to say I am not the elephant in the room, but so welcome to our first immigration coffee talk. So we want to start with the proclamation. There was a subsequent one on June 22nd. So we're going to start there just to get that one out of the way. Both proclamations are done under the authority of 212F. The reason I'm mentioning it is you're seeing a lot of proclamations out of the White House. And 212F gives the president authority to make changes that have to do with people entering the U.S. Which is why when the proclamations are issued, you'll see the changes are primarily for people coming into the U.S. So the backdrop of this proclamation is to protect American workers. Keeping in mind that despite the proclamations, what is still current are the COVID-related travel bans and the consulate closures. So they are still in place. The consulates are still closed, and restrictions for travel, even though you may or may not be affected by these proclamations, the COVID-related travel bans may still affect you in one way or another. So the April 22nd proclamation, real quickly, affects immigrant visas, people who are outside of the U.S. looking to come into the U.S. and obtain an immigrant visa. So for the most part, our family-based cases are the ones that are affected. They're usually outside waiting. Some business-related cases, diversity visa. So that's generally the April 22nd proclamation. Immigrant visas, green card-based entries. There are some exceptions. LPRs, U.S. citizens, spouses, children of U.S. citizens. Now comes June 22nd. June 22nd, President Trump signs a proclamation which in effect extends the April 22nd proclamation through December 2020, December 31st, 2020. The June 22nd proclamation, effective on June 24th, also in effect until the end of December, with the caveat that it can be extended or modified if the Secretary of Labor or Secretary of Homeland Security decide. So what is the June 22nd proclamation? June 22nd proclamation, I'm going to go through who it affects, who it doesn't affect, and then also what we expect is coming later. So who it affects? It affects people who are outside of the US without a visa, a non-immigrant visa. So people who have H-1Bs, L-1s, H-2s, and most J-1s, and all their family members, all their dependents. Anybody who is outside of the US when this proclamation was signed, does not have a visa to come in, will have to wait until the end of December or beyond, where that's left to be decided, to apply for a visa to come back in. We want to emphasize the categories it does not cover, because we know, we went through our attendees, so we know who's attending, and we wanted to make sure it put you at ease which categories it doesn't cover. It doesn't include E1, E2s. It doesn't include TNs. It doesn't include H1B1s or Canadians. There's some clarifications, as with each promulgation. We'll start getting clarifications from the government because we need some interpretations. Things are sometimes really written a little broadly, and they seem to sweep a lot of things under the rug. But those categories, for the moment, not affected, okay? There's also exceptions, just like your April 22nd proclamation, your US citizens, your spouses and children of US citizens, LPRs, and other categories that they deem are in national interest. People who are essential to the US food supply chain can also seek exemptions. People whose work is in national interest can also seek exemptions. So for those of our folks who are affected, we can work out and see if there's possible exemption that will allow you to apply for your visa to come back in. Okay? National interest. National interest is broadly mentioned, and we are waiting further instructions and directions of what will qualify. In the end, the consulates are the ones that will make the determinations on what's national interest.
Well, I have a question. What if you know, for most, this was done pretty quickly. For most immigrants who have a visa to travel on an L, even though they may not have an extension here, what can they do? And let's say in this case it's an L or an H-1B visa holder.
If they have a valid visa, there can be an exit and a reentry on that visa so long as it's valid currently. If there is no valid visa, we are advising no travel at this moment until everything settles. We're obviously waiting. Elections are in November. We'll see what happens after the dust settles. But if you are here, you're an L, you're an H, we are doing extensions in the US. So beyond anything, the most important thing is do not travel until you communicate with your HR.
But what if you have no visa, but your H-1B or L-1B time is running out?
We'll be doing the extensions in the US.
What about for the COVID travel ban in the U.S., at the U.S. consulates? Do you see any movement there at all?
There's been no, the consulates are still not taking appointments. We are monitoring them very closely. There's some that open them for emergency basis. So we're periodically checking them. And then you have your general COVID country-based travel bans from countries that are coming from the Schengen territories. If you're coming from Ireland, Brazil is the latest country that was added. If you're in any of these countries for the last 14 days, you cannot come in. It doesn't mean that you can't go to another country, stay over for 14 days, that's not on the list, and then make your entry.
Some families, as you know, have been separated by this. Some people are here in the U.S. Some people have been here working, and all of a sudden COVID happened. So for a moment, we're going to go back in time if people remember the time before the pandemic. And during that time, like most people in the United States and all this amazing global challenge here, we were told that we had to leave work in New York, in Florida, all over. It kind of just hit us. And for people like me, I was kind of shocked. And for people like Mr. Siegel, Peter, he really probably got a lot of calls, and if you could take us through that impact on employment and those stages that happened.
So let me go briefly and try to explain the situation over the past 3 months. As Patsy said initially, the world has changed dramatically. 4 months ago, I was in actually New York City giving a speech to HR directors from around the country, and we talked about the hottest issues of the day for employment and labor law. Obviously, there was no discussion of COVID. The issues were Me Too, sexual harassment, mental health issues in the workplace, workplace violence. Those were the issues that were being discussed. Now, in June, 4 months later, the employment law world has changed more dramatically and more quickly than ever in history. What we call phase one was March. That was really the shock to the US labor system. The shock being the sudden closure of businesses, unemployment moving up to 40 million folks in need of unemployment compensation, and many businesses shutting down. So what did we deal with? We dealt with unemployment compensation, we dealt with mass layoffs, we dealt with furloughs, we dealt with wage reductions. Companies tried their best to stay afloat and to try to manage through this shock to the system. Then we go to phase two. Phase two is what we call this explosion of federal legislation. Federal legislation such as the CARES Act in March, which, as you know, hopefully understand that it had to do with the PPP program, loans for small businesses with fewer than 500 employees, the expansion of unemployment compensation, individual checks up to $1,200 for millions of Americans. So that was the effort to try to fix the problem. Now we're in the third stage, probably the most important, which is the reopening. And what the reopening really is, the efforts of employers to bring everybody back to work in a safe climate in order to protect their workers and to protect their business. And those are the issues that we're dealing with today with companies all over the country. We're dealing with issues of sanitizing, of hygiene, of having appropriate PPE, personal protective equipment in the workplace, social distancing, staggered work schedules, remote access to the workplace, whether or not to engage in temperature testing versus self-certification medical forms. All of these issues are brand new. All of these issues have become somewhat of a struggle for HR, for ownership, for C-suites around the country. And what's more important than ever is that business owners work with their lawyers, with their accountants, with their financial advisors to ensure that whatever they are doing as part of the reopening is in compliance with all the changes in federal, state, and local law.
As people are getting back to work, I mean, what if employees and is it uniform throughout the U.S.? And what if certain employees don't feel comfortable going back to work?
Yeah, that's a great question, Patsy, and it's really been another struggle.
Well, it's not really mine. It's in stuff I'm getting.
Well, and here's the short answer. Is there uniformity? The answer is no, okay? In Florida, the rules are different than in Texas, which is different than Arizona, which is different than California. It is a system now where the problem is many folks are looking for one uniform standard, one uniform guideline. I mentioned temperature checks for the simple reason that that is an issue where some companies feel very strongly that they're helpful. Other companies and their lawyers feel that it's causing more problems than it's solving. There is no national law about temperature check. It differs county to county, city to city, state to state. So a lot of clients will call me, and what we'll tell them is there's not one size fits all. People who work with me for many years know I am not a fan of temperature checks in the workplace. There's certain exceptions where I think it's okay, but the problem, for instance, with temperature checks is not the idea, it's the implementation. Too many companies I know are already in trouble because they had the wrong person administer the temperature check. They weren't able to keep the temperature check results confidential. They disseminated improperly in violation of HIPAA certain results that certain employees had. They didn't temperature check everybody. Thus, they were accused of discrimination because certain groups of employees were not subject to temperature checks. So that's an example where I tell companies, these are your options. This is what the law in your particular jurisdiction allows, but you need to be sure that the implementation is proper. Because even though the intention might be good, if your implementation of this new HR structure is not done legally and properly, you will get sued.
And a final question, another question to Marcela and then back to Peter. Marcela, so I'm back to work. I have an H-1B extension. This is my scenario. I have an H-1B extension. I'm back to work. And my visa, I can use it once my extension, in this case, my extension's approved. My visa's good for the next 3 years. Assuming COVID in different countries require different things to get in, I'm okay. Peter makes an announcement that we're doing furloughs again. What would happen to me as an H-1B if there was a layoff or a wage reduction?
So in the immigration context, it affects it very differently because the H-1Bs, particularly like E3s, like H-1B1s are governed by the labor condition application. The labor condition application is with the Department of Labor. It implements some wage obligations. Within the immigration context, you have to maintain status. So there's a couple of issues. One is the wage obligations, what you have to report. And the other one is if you're not maintaining status, even if it's a furlough, or a leave of absence, if it's not at your request or at your behest, you're not maintaining status. So at that point, you're not maintaining your H-1B status. It would require you to either look for new employment for a change of employer or depart within the earliest that you can. There is a 60-day provision that was implemented a couple years ago. And it's the earliest of 60 days, the earlier of 60 days or when your status expires. You have that time to seek a change of employer and or theoretically to depart the U.S.
Peter, I'm hearing things in different parts of the country that when I go back to work, I might just be tested. Can a company require me to be tested?
So I've been practicing employment law now for almost 28 years. For 28 years, the law was very clear. You are not allowed as an employer to administer medical examinations in the workplace. A 100% prohibition. A month and a half ago, the law changed dramatically. And now, for the first time ever, the U.S. Equal Employment Opportunity Commission has stated in writing, as part of her new regulation, that employers, yes, can affirmatively administer medical examinations, such as a temperature check, in the workplace, as long as certain conditions are met. The question I had from a client last week was, Peter, we're doing temperature checks, so that means it's okay if we conduct antibody tests of all my employees. I told them no, because a week ago, the EOC said, while temperature checks are permissible, antibody tests are illegal to do at the workplace or to require as a condition of employment. So the answer is yes. There's certain things you can do temperature checks if you do it properly. You also can do medical self-certifications, which many of you have probably dealt with, where you have your employees begin every workday by filling out a form and basically making an attestation that they don't have any symptoms consistent with COVID-19. Those are two examples where it is permissible.
Okay, and you know, as to Marcela, Marcela, what if we're tested, and foreign nationals have to be tested as well, and we're doing our green card here in the United States, so we don't have to worry about the U.S. consulate and doing immigrant visas abroad. Would that impact us in any way? Do you envision a time where it could be considered by the World Health Organization as contagious disease, anything that would affect us in that manner?
Are you talking about inadmissibility?
Yes.
Oh, okay. There hasn't been anything that has come out in terms of inadmissibility. That's for medical reasons, for a contagious disease. So we're waiting for further clarification on how that's going to affect the immigrant visa component.
Okay, and then finally, would the wage reduction, of course, make any difference if I was, say, on an E or an L visa?
Okay, when you're dealing with an E and L, you're not filing with these wage obligations under the Department of Labor. E and Ls have a little more flexibility in terms of changes. None of the changes should be permanent. They shouldn't be anything meaningful. There shouldn't be a significant change. So if you're an L and they reduce some hours, or if you're on an E and that changes a few hours, that for the most part does not require an amendment. H-1Bs, if that were the case, going full-time to part-time, or a significant wage change as well, would require an amendment.
Peter, a question for both you and Marcela. Just going back to the whole quarantine and COVID, two questions. One, if temperature checks are okay, and but antibodies are still not okay, would you use, or could you use pulse oximeters to check health?
I lost you at the end. You said if antibodies are not okay, could you what?
Use pulse. I'm sorry, I'm not very clear. Oximeters.
Yeah, that issue has not been addressed by the EEOC at this point. So again, if it were my business, I would limit any type of examination to what has been expressly approved by the government. And the reason is, if you start engaging in certain types of medical examinations or evaluations that are beyond the scope of what is at this point today permissible, you run the risk of violating the Americans with Disabilities Act, and that's something that I would not recommend at this moment. Again, the government has been asked to expand over the next 1 to 2 to 3 months other type of testing and examinations which may be permissible. But at this point, it very much is limited to temperature checks and, as I said, the written self-certification.
Okay. Marcela, a quick question to you. As you had mentioned many, many times, they're not issuing any more H-1B visas at the U.S. consulate, period. So when and if the U.S. consulate opens, nothing on the horizon for the L's and H-1Bs. However, let's say I enter the U.S. on my, H-1B, that's still good till 2023 visa. I come in, but I come from a country that still has a travel ban. For Peter, if I come from a country where we have ban, am I required to be tested to go to work? And for Marcela, I won't be able to enter the United States. Can I hang out in the Bahamas for 14 days?
Peter, you want to go first?
Sure. I mean, from our perspective, from the employment law perspective, in virtually every state now, you certainly could, in that scenario, require a temperature check as a condition of return. More companies are opting to do a self-quarantine for 14 days upon return, because as we know from CDC, that is the accepted incubation period. So you have some options there. Have the person work remotely for a couple of weeks. Or if you want a temperature check in order to expedite the return, you can do that as well. So as I said before, medical examinations, this is a window right now where it is acceptable. And the reason is, as an employer, the government's position is your single and foremost obligation is to keep your workforce healthy. And that goal, that singular goal, has given us as employers more leeway to do these sort of things.
Okay. And in the immigration context, if you have a valid visa, you can return, but you have to keep that interplay with the COVID-related travel bans in mind. If you're coming from a Schengen territory, you have to lay over in another country for 14 days before you make an entry. Brazil, being the last country that was added. There hasn't been an indication of when these will be lifted. Trump had indicated that there might be some kind of an announcement or something in July, but left to be seen. He might say July and might be in August. So definitely just do everything with caution. If you are going to depart, keep in mind what country you're traveling to and what restrictions the U.S. has with them. And
currently, no H are being issued.
Currently, no H unless you fall under the exceptions. There are some exceptions. The food industry, national interest industry. So if you think that you may fall in those categories, it's good to discuss.
And there's exceptions on coming in as well, you know, if you are needed, and, you know, so we can do that for a later date. You guys, we have like a minute left. I've been trying to hone in all your questions, and I know they just cut us off at noon. So I just want to be sure in these last moments to be able to thank everyone for participating. Our next one, especially Peter Siegel and Marcela Bermudez, for all your, you know, practical insight. We're going to be doing this in July again, of course, with our neighboring border countries. We should probably get their employment lawyers on as well to see what everyone's doing. But together we'll get all through this, and thank you again for joining us on a Friday, and thank you all for participating. I hope we were able to answer most of the questions.
And whatever questions we couldn't get to, we'll try to get to them after.
Peter?
Thank you very much, everyone.
All right. Thank you.
Thank you.